Hello, everybody.
Mr. Ambrose, anything further at this time?
That's it for me, Your Honor. Thank you.
Any questions about the court's orders, Mr. Malone?
No, sir.
All right. Good luck to you. I hope you're successful on this probation.
Thank you.
If there's nothing further, then the Eric Malone matter will currently be in recess, and this meeting may be ended for all.
And Judge,
Yes?
we have Miss Carson out in the hallway. What would you like us to do with her?
You have Miss Carson out in the hallway.
All
As far as I'm
right.
concerned, she should go to. She probably should just be in custody. She didn't appear for her scheduled court hearing this morning, Mr. Ambrose. What are your intentions here?
Well, if the court will allow us, the plan that we had is Miss Carson would be entering pleas of no contest to counts 1 and 2, and then getting her set for sentencing. However, you tell us what you want to do, Your Honor.
Just a moment, counsel.
Yes, Judge.
All right, were you going to go out and get her, Mr. Ambrose, or what were your
Yes.
intentions?
Yep, she's right in the hallway, Judge. I'd grab her right now. We'll go on.
All right, at this time, the court recalls the case of State versus JoAnn Carson. It's case number 2024 CR 14. Jill Gillette appears as before as Greenwood County Attorney. Chris Ambrose appears as before as defense counsel for JoAnn Carson. JoAnn Carson was scheduled to be in this court at 11 o'clock a.m. this morning for court. At about 24 minutes after 11, the court declared bond forfeiture, bench warrant issue for her arrest, with her to be held on a no bond hold due to her failure to appear. Ms. Carson, I don't understand. You were in court when the court told you the time you needed to appear and where to appear at 11 o'clock this morning, and you weren't here for a substantial period after that. Why didn't you take your appearance requirement seriously?
I did take it seriously. It's just I didn't get here. Last time. This is the first
Yeah,
time
I'm
I've
having
actually been to
difficulty
court.
hearing you, so please try to speak as clearly as you can.
This is the first time I've actually been to court and physically in court.
And so did you
So
misunderstand how long
what
it
am I
was?
supposed to get out of that, Ms. Carson's?
Yeah, where was that? That's what.
You didn't know where the Greenwood County Courthouse in Eureka was located?
Because I'm not from here.
Where are you from?
Arma, Pittsburgh, Kansas.
Well, I would think if you didn't know for sure where you were going, you would allow even extra time to make sure that you did appear at the time you were scheduled to. I mean, this wasn't an early morning appearance set. This was 11 o'clock a.m.
I left at like 8 o'clock. I still didn't get there. It was longer than what I expected.
What announcement is made regarding case status?
Your Honor, the plan today, if the court would allow it, is Ms. Carson would be entering a no contest plea to counts 1 and 2, driving under the influence, 4th or subsequent, a level 6 non-person felony, and count 2, possession of methamphetamine, a severity level 5 drug felony. Upon entry of that plea, the state would dismiss the balance of the complaint.
All right, there must be an amended charging document in this case. I have the original before me. Was the count 1 upgraded after August the 15th? Actually, I have the amended complaint before me, filed on August the 15th, alleging a Class B misdemeanor in count 1 and a level 5 drug felony in count 2.
Give me 1 second, Judge. I'm confused here.
Mr. Gillette, could you help clarify the situation? Has there been another amended complaint and information filed after August 15 of 2024?
Judge, we ordered many certified copies of documents of her history because there are prior cases. And so with the specific dates, I believe that the Class B non-person misdemeanor is correct.
All right.
And that's correct, Judge. I'm sorry. I was looking at the wrong complaint. It is correct. It's the admitted complaint's the one we're working off of, counts 1 and 2. Count 1 being a Class B misdemeanor.
It was like a month's thing within a year time frame, Judge. It was like it became a Class B and just because of a very short time frame from her prior.
All right. All right, Ms. Carson, if you're going to plead guilty to a felony or no contest to a felony, I've got a number of questions I need to ask you regarding the taking of such a plea. If there's something asked of you that you do not understand, I'll give you the opportunity to confer privately with your lawyer, Mr. Ambrose, before going further. Let the court know if you need that time to get advice, okay?
Okay.
I also will need you to speak clearly with all your responses. I want to make sure all participants can hear and understand your responses to the court's questions.
Okay.
State your full legal name for the record.
JoAnn Lee Carson,
How old are you right now?
48,
What's the highest level of education that you've attained?
high school.
Do you believe you're going to have difficulty understanding the legal concepts that we're going to be discussing in court here today?
No.
All right. Have you ever been adjudged to be mentally ill?
Am I not? I have mental problems, yes.
Okay, so you have had a mental health diagnosis before?
Yes.
Because of that, are you on any type of mental health related medication?
I take Wellbutrin.
Okay, does that help your mental condition?
Yes.
Okay, do you feel impaired in any way as you sit beside Mr. Ambrose today?
No.
So you don't feel like you're under the influence of any drug or alcohol for that matter, correct?
No. Correct.
All right. So you believe, Ms. Carson, that your mind is clear and you have a full understanding of what's going on here?
I do.
I'm sorry, I didn't hear the response.
I do.
All right. All right. Did you receive a copy of the amended complaint and information in this case?
Yes.
You understand the nature of the charge of driving under the influence of alcohol or drugs?
Yes.
Do you understand the nature of the charge of unlawful possession of methamphetamine?
I do.
All right. Do you understand that when you enter a plea of no contest, you are not admitting that you committed these acts, but you're also not contesting that you be convicted just the same? Do you understand that?
Yes.
You understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to these charges?
Yes.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Ambrose, and that at such a trial you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes.
You understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could elect to testify in your case if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described.
I do.
Also understand that you have a right to a trial by jury. Before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes.
Also understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
I do.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes.
Do you further understand that you may appeal your sentence after entering pleas of no contest, but generally you may not appeal your judgments of conviction after entering such pleas?
Yes.
You understand the possible penalties that could be imposed as a result of these no contest pleas that you're attempting to make?
Yes.
Let's go over those. For the DUI charge in count 1, a Class B misdemeanor, that's punishable by a minimum of 48 hours in jail and up to 6 months in the county jail, and at least a $750 fine and up to a $1,000 fine. You understand that?
Yes.
Unlawful possession of a controlled substance, methamphetamine, is a level 5 drug felony. It's punishable by up to a $100,000 fine. Do you understand that?
Yes.
In addition to the fine, under the drug grid, under the Kansas Sentencing Guidelines Act, in the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As you sit today, Ms. Carson, we do not know with certainty what your criminal history is. You better than anyone else here should know what your own criminal record looks like, but that will be researched by the Court Services Department, and based on the outcome of that research as of the date of your sentencing, that will determine where you fall along the level 5 drug line, and then you'll be sentenced accordingly. Do you understand that?
Yes.
You also understand that if you have a person felony on your record already, at time of sentencing, you'll be presumptive prison.
I don't have any personal feelings.
I'm
But
just
if you
telling
did-
you. Do you understand that if you did, you would be
Yes.
presumptive prison at sentencing?
Yes.
All right. Did your attorney discuss with you the concept of Senate Bill 123?
Yes.
Certain offenders, because of a high risk needs assessment score, combined with an assessment which finds that they have a high probability of substance abuse disorder, may be mandatorily placed into a state-sponsored drug treatment program, which would be a requirement that you would complete in the case. Do you understand that?
Yes.
I'm sorry, I didn't hear the response.
Yes, I do.
All right. In addition to any fine that could be assessed in the case, are you aware that you could be required to pay certain fees and court costs and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
You also understand that as a direct consequence of this plea, you'll be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision as deemed appropriate by the court at time of sentencing.
Yes.
You understand that both probation and post-release supervision periods start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes.
You understand that if there are any special sentencing rules that apply to you and your situation, Ms. Carson, that this could affect your eligibility for probation or otherwise affect your sentence.
Yes, I understand.
Now, have you had an ample opportunity to discuss your legal matters with your counsel, Mr. Ambrose, before proceeding here today?
Yes, I have.
You want any more time with him privately now before we go further?
I think we're okay to go further.
I didn't hear that.
I think we're okay to go further.
All right. Are you satisfied with the services and advice given to you by your lawyer?
Yes.
Now, this no contest plea that you're attempting to make to these two charges hasn't been based upon any threat or promises as to what this court will do in regards to your sentencing or any other type of threat or promise?
Yes. Nobody's ever threatened me or nothing. No.
You understand that if there are any plea discussions or deals between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
All right. How do you plead to the charge in count one, driving under the influence of alcohol or drugs?
No contest.
And how do you plead to unlawful possession of methamphetamine, a drug felony, in count 2?
No contest.
All right. You can have a brief and concise statement regarding factual basis, Ms. Gillette.
Yes, Your Honor. In this matter, on January 7th, 2024, the defendant was stopped by Deputy Blake Fisher. She was stopped on US 400 at approximately the 325-mile marker, which is within the bounds of Greenwood County, Kansas. The vehicle was lingering within the left-hand lane and the passing lane, and it continued eastbound towards the location. He observed the driver's side portion of the vehicle cross the double yellow line which separates the east and westbound lanes of travel. As the vehicle crossed the double yellow center line, the front of the vehicle listed above was facing towards the stationary patrol vehicle, which is a potential hazard. So he had noticed her there, and then he conducted a U-turn and went and stopped her. The above vehicle, her vehicle did merge into the right-hand lane without using its signal, and the vehicle then pulled partially onto the shoulder of the roadway, and the vehicle was half out in the southernmost eastbound lane of travel and not parked properly on the highway. After making contact with her, he determined that she was having some issues. He ran her through his in-car terminal to ensure there weren't any arrests, and through dispatch, any warrants out for her arrest, and she did have a valid license and no outstanding warrants. He did try to gather the insurance information and allowed her to make phone calls. She was not able to ever pull up any car insurance. She had informed him she had prior alcoholic and had 3 DUIs in the past, and that she had prescriptions and different things with her. The canine came to the stop as she was not free to leave and had a positive alert on the vehicle. A subsequent probable cause search revealed many different items, and they ended up taking her in and testing her. She ended up having a blood drawn done. The items tested at the KBI lab tested positive for methamphetamine with a pipe that she had. Then for her blood draw, she was positive for methamphetamine, amphetamine, buprenorphine, diazepam, nordiazepam, bromazepam, and those are all of the substances that were in her system at the time of driving and operating the vehicle upon 400 highway within the bounds of Greenwood County, constituting a combination of drugs that would impair the ability of the driver to be able to drive a vehicle.
Very well. Ms. Carson, do you now freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for driving under the influence of alcohol or drugs, a Class B non-person misdemeanor, and unlawful possession of methamphetamine, a level 5 drug felony?
I do, yes.
Mr. Ambrose, do you know of any legal reason why the court should not accept your client's pleas?
No, Your Honor.
Mr. Gillette, are you aware of any such legal reason why the court shouldn't accept her pleas?
No, sir.
All right. Ms. Carson, are you aware of a legal reason or any other good reason why the court shouldn't accept your pleas here today?
No.
Okay. Court will accept the no contest pleas made by the defendant and finds that those pleas are made voluntarily. She has an understanding of the nature of her charges and the consequences of her pleas. The factual basis for the 2 charges does exist. Court finds her guilty and adjudges her therefore convicted of driving under the influence of alcohol or drugs, a Class B non-person misdemeanor in count 1, and unlawful possession of methamphetamine in count 2, a level 5 drug felony. All other charges with the information are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Ms. Carson's criminal history, and the court will set an appropriate date for sentencing. Thursday, December 26th,
That works for us, Judge.
11 o'clock a.m.
That works, Your Honor.
Ms. Carson, that's 11 o'clock a.m. Central Time. You're not allowed to be late. Now that you know exactly how long it takes to get to Eureka from where it is that you live, you should have no trouble getting here early and being available to the court when I want to start court at 11 o'clock on Thursday, December the 26th. I want to set aside the court's earlier order regarding bond forfeiture, bench, and no bond hold, reinstate or prior bond. With some hesitancy, Ms. Carson, I just don't know if you take this whole thing seriously or not.
I take it very seriously. I
No.
just didn't realize that part.
11 o'clock a.m., Thursday, December the 26th. Defendant is ordered to appear at the Greenwood County Courthouse in Eureka, Kansas to participate in that sentencing. 11 o'clock, Thursday, December 26th. I won't approve that you would participate from any other location but the courthouse. All right, Ms. Carson?
Yes.
The court also ordered the defendant to fully comply with any requested risk needs assessment or substance abuse evaluation, which is requested of her as part of the pre-sentence process. I'm going to need Ms. Carson to contact the Greenwood County Court Services Department before she leaves the building. Mr. Ambrose, if she doesn't know the way, could you show her?
Yes, I can, Judge.
Okay. And then follow their direction, Ms. Carson, regarding what you need to do to facilitate and complete the pre-sentence investigation process. Okay?
Okay.
Ms. Gillette, anything else we need to address at this time?
I can't think of anything else, Your Honor. Thank you.
Mr. Ambrose, anything further currently?
No, Your Honor. Thank you.
Ms. Carson, do you have any questions about what we've done here?
No, sir.
Okay, you're going to go talk to a probation officer, court services officer, as soon as we get done here. Don't leave the building until that conversation's taken place, okay?
Okay.
All right.
One
There's
question,
nothing-
Judge, if
Go
that
ahead.
if that warrant is still in your queue or with the clerk's office, we just ask that one of you reject it back to us.
The court will do that.
Thank you.
Thank you, Judge.
Be safe, be well, sleep sweet, and much love.